the Institute for Speech, an advocacy group aimed at protecting First Amendment rights. Brad is one of the nation's foremost experts on campaign finance law. He literally wrote a textbook on the issue, which I use to teach my election law class in an attempt to introduce as many young law students as possible to the Brad Smith free speech perspective. He served as commissioner on the Federal Election Commission, resigning in 2005. A recent New York Times story referred to Smith as the intellectual powerhouse of the movement to roll back campaign finance restrictions. Smith is a senior fellow for the Goldwater Institute and a member of the Board of Scholars of the Mackinac Center for Public Policy. He's a cum laude graduate of Harvard Law School and Kalamazoo College and holds an honorary doctorate from Augustana College. So Mike, we're going to start with you and the floor is yours.
So thank you for having me. It was my understanding that I'm talking about the leak of the Supreme Court opinion and the fallout from that. So is that correct?
Yes, that's correct.
Okay,
absolutely.
Okay, let me start with that. So thank you for having me. I was the Colorado chapter chair of the Republican National Lawyers Association for many years. I think it was 4 election cycles. So I very much appreciate what you guys do. It's very important what you guys do. And so keep doing it because the Democrats are just going to find more creative ways to make sure that they win power, because that's all they care about is power. So thank you for having me. I clerked for Justice Gorsuch on the Supreme Court, as Audrey mentioned. I also served as the chief counsel for nominations on the Senate Judiciary Committee from 2017 to 2019 for then Chairman Chuck Grassley from Iowa, my home state. In addition to running the nominations process, my portfolio also included oversight of the federal judiciary. And I'll tell you, as a former law clerk and a former Senate Judiciary Committee oversight counsel, I find it shocking, stunning, appalling that a Supreme Court opinion, a full draft opinion, leaked out of the Supreme Court like this. It's the first time it's happened. I know that before Roe versus Wade was decided, that the results was leaked to a reporter, and then the Chief Justice threatened to do polygraph exams of the law clerks, and one of them fessed up that law clerk is the one who did it. But there's never been an instance where a draft opinion has been released. And it's very clear to me that the person who did this is trying to influence the outcome of this pending case, because Dobbs obviously is looking to overturn Roe versus Wade and Planned Parenthood versus Casey. And so the person who did this is in serious trouble. There is a very limited universe of people who could have done this. It's less than 80 people. It's the 9 justices, and clearly one of the justices did not leak this opinion. There's this draft opinion. And then each one of the justices has 4 law clerks, sometimes 5 if they share a law clerk with a retired justice. Each one of the justices has 2 to 3 administrative aides. And then there are some other people in the building who run the opinions from chambers to chambers, the draft opinions from chambers to chambers. They still do it the old school way with paper. So marshal's aides, IT people. It's probably, based upon the political reporting, it's probably a law clerk who had access to this reporter and had the backgrounds and gave this reporter the background that they gave, that this reporter reported. The Chief Justice, he was down at a conference with Justice Thomas. I think it was on the 11th Circuit down in Atlanta. He made some pretty strong comments that he's pretty upset about this, as he should be. He's appointed the Marshal of the Supreme Court to look into this. The Marshal is the head law enforcement officer of the Supreme Court. The Marshal oversees a nearly 200-person Supreme Court police force. There's a chief of police for the Supreme Court police who reports to the Marshal. There are other resources that the Marshal can bring in if they need it. They work very closely with the U.S. Marshal Service and the Justice Department. I would caution people not to bring in the political branches on this. You don't want the Senate Judiciary Committee, the House Judiciary Committee, the Biden Justice Department sticking their nose in this. This is an internal matter related to the Supreme Court, into their internal deliberations. And they need to get to the bottom of this. They need to interview all these these employees, including the law clerks, they need to take sworn statements that are subject to 18 USC 1001, depositions if they have to. They can subpoena records if they have to, emails, phone calls. If they have to polygraph people, they need to get to the bottom of this, because this is a very serious breach of protocol. It creates great damage to the Supreme Court. In order for the Supreme Court to function, you have to have the 9 chambers working very closely together to draft the majority concurring and dissenting opinions. If you don't have that trust, if you shatter that trust, if you shatter that confidentiality by leaking drafts, then the Supreme Court can't function. Maybe that's what this person intended. I think there are 2 potential motives that I can think of. One is this person is trying to change the outcome of Dobbs by getting a justice to switch their votes and maybe uphold Roe versus Wade and Casey while still upholding the state regulation of abortion, which seems to be an oral argument where the Chief Justice was leaning. And so maybe it would be a 4-2 to 3 opinion at that point. Maybe this law clerk thought, you know what, we're not going to be able to stop the court with a 5-4 or 6-3 opinion overturning Roe and Casey. So screw it. We're just going to burn down the house and create this cloud over the Supreme Court that damages the court and damages its legitimacy. And so maybe it's one or the other, maybe it's both. I don't know. But regardless, this is serious. It's actually, I think, a crime in several ways. Number one, this is federal property. And if you're misusing or stealing federal property, there's a potential crime there. It could also be obstruction of justice, because if you're doing something illegal or inappropriate to change the votes, change a judge's mind on a pending case before the courts, that could be obstruction of justice. There's also there are also crimes related to intimidation and theft of justice. So that's the internal piece of this that the Marshal of the Supreme Court can and will get to the bottom of. There's the external piece of this, that this has resulted in serious threats against Supreme Court justices, where they're getting death threats online and elsewhere. And that's where the FBI absolutely needs to get involved. That's their job. If you look at Justice Department memos, they take the lead on threats against the Supreme Court like this, and they need to get involved. And instead of White House Press Secretary Jen Psaki turning a blind eye, even some would say condoning these threats against justices, they need to step up. And I put this squarely on Attorney General Merrick Garland, Deputy Attorney General Lisa Monaco, FBI Director Chris Wray, and the U.S. attorneys in Maryland and the Eastern District of Virginia and in D.C. They need to step up. You cannot have people threatening Supreme Court justices like this on pending cases. That's obstruction of justice. That's threatening federal officials. That's threatening Supreme Court justices. There are several statutes on point. And there's also the doxing of Supreme Court justices' home addresses. This is not a free speech issue, right? There are time, place, and manner restrictions for your free speech. And there is a federal statute, 18 USC 1507, that specifically makes it felony obstruction of justice to go protest for the purposes of intimidating justices at their homes. Remember, you have to balance the First Amendment rights of protesters versus the due process rights of litigants before the courts, right? And when you're threatening justices at your home, the due process rights of litigants before the court are going to trump those First Amendment rights. And so that's I will leave it at that, and I'm happy to answer any questions that you have.
Thank you so much, Mike. Let's turn it over to Brad, and then we'll do questions at the end.
Okay, well, thank you, Audrey. Thank you, Mike, for your comments. It's always a pleasure to be back with my friends at RNLA. I've seen a couple titles for this. One calling it "The Left's War on Free Speech and Legitimacy of Our Institutions." I'll actually be talking more about that in a 36-hour webinar I'm going to do. No, I mean, you could go on forever about that. And another's talking about the Biden's Ministry of Truth. But I was originally asked to address at length also the Disclose Act, and I'll spend much of my time talking about that and hitting that point again. Let me begin by noting that when I was a young man years ago, the conventional wisdom was that the left favored free speech and the right, not so much. Whatever the accuracy of that wisdom way back in around 1970 or 75, I think it certainly lacks much truth today. The breaking point for the left's loss of commitment to free speech really has been campaign finance reform. As John Samples notes in his book, The Fallacy of Campaign Finance Reform, by the late 1960s, smart Democratic politicians and operatives grasped that the public was moving away from the New Deal, that old majority was disappearing. And this was reinforced by the Republican sweep way back in the 1966 midterms, and then by Nixon's 1968 presidential win, which marked the poorest Democratic performance in a presidential race in 40 years. Moreover, the Republicans clearly had the financial means to act on these growing doubts of the electorate. Money is, in politics, a crucial means for articulating views and electoral alternatives and winning voters over by financing speech. So the result was the Federal Election Campaign Act, passed largely on Democratic votes in 1971 and substantially amended by the Democratic post-Watergate majority in 1974. Over the next 30 years, almost all liberal academic scholarship on free speech was about attempting to explain why political speech, traditionally at the core of the First Amendment, was in fact so important that it couldn't be left to the tender mercies of the First Amendment. So that by 2002, the McCain-Feingold Act passed almost entirely on Democratic votes. By 2014, with Republicans poised to take control of the Senate, every single Democratic senator voted in favor of amending the Constitution to allow greater regulation of political speech. And in 2019, once again, every single Senate Democrat supported a constitutional amendment to repeal portions of the First Amendment regarding political speech. Unfortunately, this growing fear of open political speech, again reinforced now by half a century of legal scholarship, shows up most vividly in the new progressive movement, where we find an outright fear and near hysteria, for example, over the possibility that Twitter will do less to censor conservative speech going forward. And in last week's revelation that the Biden administration is establishing the Disinformation Governance Board, which should always be called, as I call it, the DGB, because it conjures up certain memories which may seem at least mildly appropriate, if something of an overstatement. Now that that intro suggests that I want to be spending the rest of the time giving you perhaps some real red meat and Democratic bashing, but sadly, no. Instead, I am going to try to address some of the specifics of some of the more arcane legislative assaults that appear in the Democrats' proposed For the People Act. Now, remember, the For the People Act has stalled. It's not going to pass this Congress, but the Democrats may yet make a last-ditch attempt to pass individual parts of the bill, and the anti-speech parts may be the parts that are the most likely, candidates to pass. Further, note that some of these proposals the Democrats have been proposing since 2010. These remain long-term goals of the party, and we need to warn the public about them and build support for the First Amendment. So Title IV of the For the People Act includes within it three formally freestanding pieces of Democratic Party legislation. Subtitle B is the Disclose Act, which officially stands for Democracy is Strengthened by Casting Light on Speech in Elections. Although at the Institute for Free Speech, we long ago said that the acronym more appropriately stands for Democratic Incumbents Seeking to Contain Losses by Outlawing Speech in Elections. Then that has also been introduced, by the way, as a standalone bill already, S443 and HR 1334. Subtitle C is the Orwellian named Honest Ads Act, and Subtitle D is the Stand by Every Ad Act. Now, combined, these measures would do the following. First, they would unconstitutionally regulate speech at any time that promotes, attacks, supports, or opposes, that's a quote, a candidate or official. This would leave criticism of candidates and members up entirely to our scrupulously neutral bipartisan press corps. Secondly, it would force organizations to file a campaign-related disbursement report stating that their ads are, quote, in support of or opposition to an elected official mentioned in the ad, even if the ad does neither, such as an ad that might urge a member simply to support cutting off funding for, say, the DGB. It would force groups to publicly identify major donors on the face of ads about issues, even if the donor provided no funding to the ad in question. And in an age of doxing and government actions and retaliatory government actions, this will, and I believe it is intended to, silence a certain amount of conservative speech. It will subject ads to lengthy disclaimers that will eat up as much as half of the actual ad time or space bought in an ad, thereby frustrating and increasing the cost of efforts to discuss public affairs and candidates. Again, leaving us more at the mercy of our neutral bipartisan media. It will subject groups that sponsor communications about judicial nominees to campaign finance reporting laws, as if this were a candidate election. It will force organizations and foundations that make grants to other organizations to disclose their own donors if the recipient organization later makes a, quote, campaign-related disbursement, a very vague statement that could cover all kinds of things. It would increase regulation of online speech to include not only paid advertising, which is currently regulated, but also communications by groups and in some cases on individuals' own websites, social media platforms, and email groups. It would expand the definition of electioneering communication. Those of you who work in the field know this is one of the bastard children of the McCain-Feingold bill. It would expand this to include online communications that are not even targeted at the relevant electorate, and thus triggering more burdensome requirements and making inexpensive online advertising, which conservatives have used very effectively on Facebook, for example, much more difficult to use. And it would impose a new public reporting requirement on American sponsors of online issue ads by expanding the requirements for broadcast, cable, and satellite media to report information on their advertisers. And that's not all, but that touches on the high points of the Disclose Act. The For the People Act would also alter the Federal Election Commission, changing it from a bipartisan panel to one with a majority controlled by the president's party, with enhanced powers for its chairman, who would be directly appointed by the president. Under this proposal, the FEC chair would have sole power to issue subpoenas, compel testimony, prepare the agency budget, and appoint or remove the agency staff director, who people generally think is not as important as the general counsel. But remember that at the FEC, the staff director actually oversees audits, the administrative fines program, and the alternative dispute resolution program, which combined actually comprise the majority of enforcement actions or matters. This raw power play is timed to ensure that even if Republicans take the presidency in 2024, Democrats would retain a majority on the FEC at least through 2027. The proposal would also allow the general counsel to open investigations without the commission's prior approval, and it would change the legal presumption for appealing FEC decisions, so that if a respondent lost at the FEC, it could demand a hearing in the courts, but the FEC would be given Chevron deference for its interpretation of the law. On the other hand, if a respondent was victorious at the FEC, the original complainant could appeal, and the FEC's interpretation of the law favoring the respondent would not be given Chevron deference, but would be reviewed de novo. All of this has left we Republicans in the odd position of defending the FEC, which for all its faults does at least operate on an actual bipartisan basis. Finally, I can't help but notice that our old friend Sheldon Whitehouse seems to want to repeat the IRS scandal of 2013. Last week, he held a hearing in the Senate Finance Committee, Subcommittee on IRS Oversight. And after noting that the IRS scandal of 2013 never took place, that's entirely a made-up Republican story, he demanded, as by the way, he did in a hearing back in 2013 that I testified at less than a month before the IRS scandal broke. He demanded that the IRS and the Department of Justice should be vigorously prosecuting conservative-leaning 501c4 organizations for their political and public affairs advocacy. Well, you know, some say you can't argue with a donkey, but that's not correct. You can argue with a donkey, it just doesn't do any good. Of elephants, on the other hand, it's said that they never forget. And as we go into the last months of this legislation session and get into a campaign finance trail in which bigger issues are going to dominate the public mind, like runaway inflation and so on, let us remember that this legislation still remains, at least titularly, the Democrats' highest legislative priority. So we need to be vigilant. We need to explain to the American people that the Democratic goal is to pass legislation hindering the people's ability to learn what is going on in Washington and to discuss it with their fellow citizens. Thank you. And I too am open for questions. And I think we should go first to Mike, since I know he's got it on.
Yeah, sounds great. Mike, we do have a couple questions for you. If you have a few more minutes, I know you got to leave right at 2:30. So Mike, how might the leak change the internal workings of the court? How drafts are circulated, that sort of thing?
I don't think it should change anything. And I'll tell you that for the first, up until this point in our history, a draft has not leaked. And I'll tell you, this has been a particularly leaky year at the Supreme Court. Justice Breyer's announcement leaked. The whole Maskgate nonsense with my former boss, Justice Gorsuch, leaked out. I think there's a leaky clerk, and I think that leaky clerk is going to be done at the end of June or July if they're not walked out the door before then. And I think that's going to fix the problem. I don't think the Supreme Court should change anything. They have to collaborate. They have to share drafts of opinions. They're not going to send people into skiffs. So I think this is a one-off. You have a bad actor in the Supreme Court, some partisan whack job who's delusional enough to think that something that they do inside the Supreme Court is going to change the justice's opinion on a case, or it's going to blow up the Supreme Court. It just won't. It's going to have, actually, it will have the opposite effect, because what you're going to see is that justices who may have been uncertain or wavering are going to be pretty certain after this leak.
Okay, well, that's all good to hear. One more question for you before I have to go. So is threatening judges and justices becoming the new normal? What does that mean, do you think, for the future of the rule of law, and how can we as lawyers work to restore respect for the judiciary?
It can't become the new normal. It's a federal felony to threaten federal judges, whether it's at their homes or online. There are many statutes involved, and the Biden administration should be ashamed of themselves for standing by and letting this happen. I understand if the clowns in the White House, like Jen Psaki, the outgoing clown in the White House, does this stuff, but Merrick Garland, who is a former federal circuit court judge, needs to be the adult here. He needs to step up, and he needs to order the U.S. attorneys in DC, Maryland, and Eastern District of Virginia. He needs to order FBI Chris Wray to investigate these and prosecute these to the fullest extent of the law. If you're going to hunt down every goofball who took selfies on the Senate floor on January 6th, you better spend the time to go after people who are threatening the lives of Supreme Court justices.
Mm-hmm. Mm-hmm. Yeah, definitely agree with that. All right. Thank you, Mike. I know you've got to leave. Brad, we have a few questions for you as well. Can you address the harm of liberal dark money groups and the left's attempt to silence conservatives? Oh, you're on mute, Brad.
Let's get unmuted. So sure, one of the interesting things about the dark money hysteria, and by the way, it is kind of a hysteria. It's really not that much. Depending on how one defines dark money, and there's no legal definition for it, it's somewhere between about 0.6% and about 7.5% of sort of total political spending in the United States. But one of the things is that Democrats in recent years spend more of it than Republicans. And moreover, efforts to force disclosure of the donors to these organizations is much more likely to harm those Republican spenders. Why? It deals with certain dynamics of the political process, including one we're seeing now. What we're seeing now, for example, is Republican justices on the Supreme Court being doxxed, having their home address given out. Now, you don't read about that much on the conservative side. You don't read about Democrats having, a howling mob outside their house or being physically threatened in that way. And so the sort of dynamics of modern social media and what a lot of these, hardcore progressives are willing to do works against conservatives. Who simply don't want the hassle, don't want the risk. And it's not just for themselves. I mean, they sometimes have concerns about their family. They have concerns about their business and employees if those groups are boycotted. They know that any kind of boycott will be amplified by the media, by the press, whereas, conservative efforts to retaliate in the same fashion will tend to be minimized by the press and not reported on and not given credibility. So although facially neutral, rules that would force more disclosure of so-called dark money don't have a neutral effect. And of course, this is a standard that, we all know, we're all familiar with disparate impact standards. The left wants to apply them to absolutely everything in the voting rights arena. But here they seem to me, much more appropriate. It's pretty easy to set up a facially neutral rule that will mainly get the other side. And by the way, we saw that back in the 2013 IRS scandal. Remember, one of the big defenses for Democrats now is always to say, well, there were some progressive groups cornered too. Well, yes, but about 3/4 of the group were Republican. About 3/4 of the target entities were Republican or conservative leaning groups. Fewer than 10 were Democratic leaning groups, about 5%, and the rest were sort of neutral groups. They were targeted by using names such as Patriot and references to 9/11. In other words, the kind of patriotic kind of sounds, the names that Republican and conservative groups tend to use. Some liberal groups use those too. They also got caught up in the dragnet, but it was very predictable that you were mainly going to get donors to conservative groups, and you were mainly going to hassle conservative groups trying to organize and operate. So it's a very dangerous area, and it's one that is played somewhat disingenuously with these claims that, oh no, we just want to know the truth. I don't think that's true for a moment.
Yeah, thank you. So one other question we had was whether the Disclose Act would be unevenly applied to conservative and liberal organizations like labor unions, and maybe if you could talk a little bit about that.
Sure. I mean, would the Disclose Act be unequally applied? And somebody mentions labor unions in particular. One of the first things to note, sometimes I'll see Republican state lawmakers and they'll say, it's okay. I made this apply to unions too. Again, unions operate on a totally different, basis. And so applying a lot of these laws to unions simply makes no sense or really has no effect. In other words, unions are primarily funding their political activity through dues, sometimes still compulsory dues or close to compulsory dues. And those amounts typically fall below the thresholds that are disclosed. So, I don't think that's really much of an issue there. Would it be unevenly applied more generally to conservative groups? I think clearly so. And it goes with the effort to establish an FEC that is going to be under Democratic control for at least, the next 5 years, if they were to actually pass the bill this year, which I don't think they can do, but it would be for at least 5 years. And I think, that's part of the intent here is to have a level of disparate impact, we might say, in enforcement. And I always go back to reminding people, because the media remains, even with, modern social media and Fox News and all that stuff, the media remains overwhelmingly Democrat. And what most people hear is overwhelmingly liberal opinion. And so paid advertising and paid messaging is always more important to conservatives to get their message out. So if you were coming at this from a liberal standpoint, it's okay that you limit liberals a bit too, because it's going to hurt conservatives more, because the liberals have all the free media. They've got MSNBC and CNN and NBC and CBS and ABC and the New York Times and the Washington Post, and on we go.
Yeah. Well, thank you so much. We are out of time. Brad, it's always great to talk to you and hear your wonderful insights, and we'll send Mike a thank you as well. One last thing before we close. Thank you everyone for joining. We really want everyone watching who's not yet a member to join RNLA, and be sure to check out rnla.org for our daily blog posts and follow us on social media. Thank you again.
Thank you.